Dear participants, last session of our conference is continuing under the chair of Professor Keremcem Sanlı and the speakers Professor Hans Rösler, Professor Ecebaş Süzel and Associate Professor Pınar Çağlayan Aksoy.
Well, thank you. Good afternoon, everyone. Welcome to the final session of today's conference on consumer law and in the digital age. It's my great pleasure to chair this session. I first like to thank you, Bilkent University Faculty of Law, and of course the Dean, Başak Baysal, and her team for organizing this event and inviting me to chair this session. In this panel, we will explore some of the most pressing questions at the intersection of consumer law and digital transformation, ranging from collective redress and jurisdictional challenges to product liability in the age of AI and the impact of choice architecture and dark patterns on consumer autonomy. We are very fortunate to have three distinguished speakers with us today. First, we'll proceed with the order that was in the brochure. First, Professor Hans Rösler will discuss consumer collective redress in the digital age with a focus on recent developments in the case law of the Court of Justice of the European Union. Next, Professor Ecebaş Süzel will address AI, effectiveness and consumer protection, offering a product liability perspective on emerging technologies. And finally, Associate Professor Pınar Çağlayan Aksoy will examine dark patterns and choice architecture and their implications for consumer autonomy in the EU digital law. We will proceed with presentations first, followed by a short discussion, if time permits. We have 20 minutes each, I think, and we will have 15 minutes for the Q&A. With further ado, let me invite first speaker, Professor Rösler. But first, I should perhaps introduce you to the audience. Professor Hans Rösler studied law and social science at the University of Marburg with an Erasmus year at London School of Economics. After completing his first state examination with distinction, he pursued academic work in comparative law, earning his doctorate in 2003 and an LLM from Harvard Law School as a DAAD scholar. His early career included research stays at Oxford, European Commission, UNIDROIT in Rome, and New York University. From 2004 to 2013, he served as a senior research fellow at the Max Planck Institute for Comparative and International Private Law in Hamburg, where he completed his habilitation and received several academic awards. During this time, he also held visiting positions at Cambridge and founded the International Media Law Forum of the German-American Lawyers Association. Since 2014, Professor Rösler has been a professor of civil law, comparative law, and private international law at the University of Siegen, where he also directs the Institute of Media and Communications Law. He has held interim professorships at several German universities and taught internationally with guest lectures and presentations across Europe, Asia, and beyond. His research focuses on European private economic law, and his publications appear in multiple languages. So, floor is yours, Professor.
Thank you very much. Thank you for the kind words, and thank you to all for being here. It's already a late afternoon. Also, thank you to Başak and Pina for organizing this great conference. I think it's already a big success. We can see this, very great topics. And it's great to come back after 20 years, because I was here in 2006 giving lectures on UN sales law to students from Bilkent. So it's a great pleasure to be back. I already had 20 years ago a very good impression about this law school. What I'm going to speak about is collective redress, but from a specific perspective. We're going to look at a case from the European Court of Justice, and I think students like cases, they like real life, and the decisions, of course, bring that into action. What we're going to do is we're going to first look at the effects of the case, then I'm going to briefly talk what are we talking about. We are talking about international procedural law, and then we're looking at the reasoning of the European Court of Justice, and then I give some comments on its implications, because that goes beyond just the question of international jurisdiction as we see. And I want to kick off with a quote which stresses the importance of procedural law. Procedural regulations are the door, and the only door, to make real what is laid down by substantive law. So in courts it becomes real what has been put into substantive law by the legislator. So let's look at the basics. We're going to look at a ruling from the Court of Justice of the European Union, which was delivered at the end of the past year, and it's about the Apple Store. And I'm sure lots of you have Apple devices, an iPad or an iPhone. The iPhone was released in 2007, and the App Store was introduced in 2008. And it's a dispute between Apple and two organizations which have been formed in the Netherlands to fight Apple and to fight its injustice, in inverted commas. It's two foundations. You can see their names here. One is representing the app developers and business users, and the second organization is representing mobile app users who had bought apps or in-app content in the Dutch Apple Store. And it's, of course, against Apple, which has its European seat in Ireland. As you know, lots of US companies have their seat in Ireland for several reasons. And, of course, then the mother company in America. And the question is, where can the case be heard? Can it be heard in the Netherlands? Can it be heard in Ireland? Or can it be heard in California? And that's what this case is about. So let's look at the basics. It's a reference by a court, the Amsterdam District Court, to the European Court of Justice, and any member state court can ask the European Court of Justice for advice by way of a preliminary ruling to ask about a question of EU law, if it's decisive for the case, and that was the case here. And the question which was put before the Luxembourg court, can a Dutch court hear these claims? So it's about international but more majorly local jurisdiction for representative actions, and specifically about the Brussels I regulation. I'll speak about this a bit in a minute. And the regulation, which is from 2012, doesn't foresee any rules for representative actions. And if we look at the consumers, it's only if it's a natural person is acting, and with these organizations, it's not a natural person. These are foundations which try to pursue consumer claims, but they are legal persons, and these legal persons have not been party to a contract. So consumer protection from Brussels I is not working. And as we will see, the case also has broader implications for the collective redress in the digital markets, because consumers want to challenge sort of the power of big tech, and I think they can have an important rule via that technique of collective redress. What I will also address is antitrust law, because I think you're already understood there is also this connection with big tech and the gatekeeper regulation of the European Union. Okay, so let's briefly look at the development of this case. Normally, we are talking with competition law about the relationship between two competitors. Here we have a special relationship, the consumer in form of an organization trying to pursue their competition rights against Apple. So that's what you can see here with the circle. And already said on top is always the competition law side, which I've highlighted here in blue. And when we look at the history, we see that there have been these two filings, first in 2001 and point 3 then in 2022. This then went to the Amsterdam court, and it referred to the European Court of Justice. Number 6 is that the European Court of Justice had decided this is going to be our topic, and number 7 is going to be that based on this jurisdiction which was granted to the Dutch court is going to decide on the merits, on the content, because we are not that so far yet, and the reference to the European Court of Justice was about this procedural question. What I haven't highlighted in yellow is number 2 and number 5, where the Dutch courts have confirmed that there is a violation of competition law. But that's, of course, an issue of competition law and not our topic. We're talking about consumers organized in collective organizations. The foundations, they pursue a claim around 640 million euros in competition damages. So it's, Bashak must be happy, a tort law issue, right? So that's the good news. So it's for all those people who have used and bought apps via the Dutch Apple Store. And they do so by a specific act from the Netherlands, whereby they can bring collective actions, and it's implementing an EU directive, because directives needs to be implemented into the 26 member states' laws. And so if there is a qualified entity, they can pursue consumer rights issues. This one, however, this directive is limited to consumer issues, so nothing else, no non-discrimination or so forth. What the two foundations argued was that Apple has a dominant position in the market for the app distribution on iOS because it charges 30% of fees. So every time you've bought an app via the App Store, 30% went to Apple and, of course, to the Apple owners and the share owners as well. Okay, so, and on top, they have also made it difficult to pay differently than just through the app. Theoretically, it would have been possible to pay also through the website, but that was not invited, was made more difficult. And that was a violation, was presumably a violation of EU law, of EU competition law in the treaty. You can see the provisions, but also of Dutch competition law. So what has happened? Well, the developers of these apps had to be, were forced to exclusively distribute their apps via the App Store, and the only payment mechanism was the in-app payment by Apple. And of course, that limited all the possibilities for the developers of such apps. What Apple answered is pretty clear. It said, well, you know, our rules benefit security and privacy, and also on top, in procedural regard, only those people who live in the Amsterdam court can be dealt with by the Amsterdam court, and not all the others which live outside in the Netherlands of Amsterdam. Okay. I think you roughly got this 30% right, dominant position, competition law, and so forth. So let's continue now. What are we actually talking about? We're talking about international procedural law, so the question which courts have international jurisdiction. It's part of conflict of laws, and it's a bit complicated area. I love it. In past years, I've moved into that area, also because there is a lots of EU law on this, and I know nobody can read this. This is just for the full picture. There are three hurdles generally. The first one is jurisdiction, which courts can hear the case. Second one is what law applies. That's a question of private international law. And three is how to enforce, for example, a Turkish judgment in Germany. So these are the three hurdles, and they're being addressed at least partially through EU regulation. We want to zoom in on Brussels I, that's our interest, so we're going to look at Brussels I, and you can see how the piece of legislation looks like here. It's from 2012, and it's on jurisdiction in civil and commercial matters. What the jurisdictional filter is, because a court cannot have jurisdiction for all kinds of cases, is being said then in the recitals. It should be that it's highly predictable where the proceedings are being dealt with, and generally that's at the place of the defendant's domicile, and the criteria should be proximity of the court to the issue, the sound administration of justice, legal certainty, and that, of course, the places of jurisdiction are easily foreseeable. The general jurisdiction, as I've already indicated, is at where the defendant sits. The defendant sits in Ireland. So the Dutch defendants needed, or the organization needs to sue in Ireland. That's not what they want. So they need to find an alternative grounds of jurisdiction, and that can be found in the special jurisdiction. And we will zoom in on this tort law jurisdiction in a minute. Okay, so what is a tort? Well, a tort is, I think everybody knows this, what occurs as an accident and so forth, but it's also competition law. So that's why Article 7 is a hot candidate for a special jurisdiction. And if we look into this, Article 7 says jurisdiction is given where the harmful event occurred. So that's now the question we need to address. Where did the harmful event occur? And that has been dealt with in a famous decision which involved the polluting of the River Rhine. It was polluted in France, and the water then flooded, went down the River Rhine, and polluted then in the Netherlands, so that in the Netherlands the plants died because the water was polluted. And the court said in both places, the place of acting, putting the salt into the water, which was in France, but also in the Netherlands, where the harm occurred, are in heads of jurisdiction where jurisdiction can be given. Okay. So let's now return to our case, because that was environmental pollution. We live now in the digital age and want to deal with that newer questions. So let's look at what the European Court of Justice has argued. The court has basically said that the Dutch class action against Apple may be dealt with by a single court. So one court in the Netherlands can deal with all issues which have arisen within the Netherlands. So it does not have to be the case that the defendants actually sit in the Amsterdam court, but district, but also consumers which sit outside this district court can be dealt with by this court. And this, of course, centralizes the proceedings, which is very helpful, in one court, and they do not need to be split up. And this is now what EU law says, and of course this has far-reaching consequences also beyond this, makes it much easier to enforce substantive law in this area. Okay, so the court can now hear all these cases, and the background was that the Dutch store was nationwide. Once you had an Apple ID, you were automatically directed to the Apple Store Netherlands. That was in Dutch language, and some of the apps were locally targeted. That somehow resembles consumer law. I don't want to go too much into this, but for the fans of consumer law and so forth, there is this directive act criterion, which somehow is mirrored a bit in the decision of the European Court of Justice, though it doesn't mention this. Okay, so what did the court held? Well, as I already said, the court can deal with all anti-competitive conduct in that member state if this court has jurisdiction according to national law, and that was the case here. The international jurisdiction, by the way, was clearly given because there was already case law on competition law, so the Amsterdam court only asked about local jurisdiction, whether it has local jurisdiction. And what the European Court of Justice does, it synchronizes international jurisdiction based on Article 7, this Brussels I regulation, with the local jurisdiction, which is also addressed in there. It doesn't specifically say so, but people understand this norm as covering both international as well local jurisdiction within here Netherlands. Which courts can hear? Is it Groningen or is it Amsterdam? So also this is being addressed by Article 7 of this Brussels regulation. And the court said the damage occurred in the entire territory of the Netherlands, so the market is affected by this allegedly anti-competitive conduct, regardless where the purchase has occurred, because the Dutch market as a whole was directed by the Apple Store Netherlands. When we look at the reasoning, it's quite legal policy oriented, which we have very often at the European Court of Justice. You know, it's just one of their styles. It's not so dogmatic as, for example, German law or other laws. First argument was proximity. There is sufficient proximity of the Dutch court to these cases, and it's predictable for Apple, so they could have foreseen that they got sued even for all these issues in front of the Amsterdam District Court. And it also helps the sound administration of justice because it makes it easier. All the cases will be heard by one court, and there will not be divergent decisions between Court A from the Netherlands and Court B from the Netherlands. And the court also understands how complicated competition issues can be regarding the factual analysis, but also the economic issues which need to be taken into account. And as a last aspect, it's being mentioned that the injured persons need to pursue their rights. And if we look at EU law, there's lots of protection of weaker parties, not just consumers, but also employees and people who are disabled, who are getting discriminated. And there's lots of talk about equality also in primary law and so forth. And the consequence, the court says, a lot speaks in favor of a centralization of jurisdiction in one place, and he refers here to its case law on competition law in general. There's been quite some criticism regarding this case. Burkhard Hess, a famous procedural lawyer, said it's judicial lawmaking by the European Court of Justice. We have this argument very often, and the European Court of Justice should have waited, or parties involved, for the reform of Brussels I, which is starting. It's beginning. People are starting to begin to discuss about any reform. But I think this criticism is too hard, because if we look at sort of what are the two possible connecting factors, the two principles. It can either be the country of origin. That's what we have with the free movement of goods. If the goods is allowed in one country, it should also be allowed basically in the other countries. Okay, so that's the idea of the free market. That's the country of origin principle. So where it comes from, that's decisive. The second principle which we have is the market principle. So where something is targeted to which market it is being addressed is decisive. And we find this in the Article 6 of the Rome II regulation on competition law. There, this marketplace is the decisive connecting factor. Okay, so I find it systematically coherent, not just legal policy arguments, but I think also if we look at Article 6, it's a good reason why the marketplace here, the whole of the Netherlands, should be decisive. The point is, of course, whether not too much forum shopping is being invited here, but we need to keep in mind that consumer protection is an aim of the Brussels regulation. There are specific provisions which protect the consumer more. You can see this here on this illustration than normal plaintiffs and defendants. And of course, EU in general pursues a big sort of policy of consumer protection. Okay. Now let's come to the last chapter. We don't have so much time. Sorry for rushing. I want to speak about now the implications. So what are the implications of these decisions? Well, first of all, this decision makes it easier to put pressure on tech giants because now collective enforcement is more workable and more likely, also against not just app stores, but online marketplaces, social media networks, and all kind of other places. And it's in line with the global trend of platform regulation that is on the rise. This is being seen more and more. We already had this here at the conference being seen as an important issue. I also find this case very fascinating because it's a collective private enforcement. It's not waiting for the public authorities, here the European Commission or the antitrust authorities in the Netherlands, but it's the private people, the citizens who, through these organizations, consumer organizations which have organized themselves, pursue competition law. And that's what we can also find in a very important decision, the Van Gent and Loss decision, where it was being said that rights from the Treaty of the European Union are given to the individuals in the member states. And the argument was then the individual who has been given rights has an incentive to enforce them. So he himself, this person who has been given EU rights, has an incentive to enforce them and is effectively enforcing EU law. And with a similar mechanism of a decentralized enforcement through this collective redress. And we also find the general importance of private enforcement in competition law. There are quite a few cases and so forth. That's, as I said, a different road I don't want to go down, but that's systematically coherent. I also said it's not just a consumer law issue. We also need to keep in mind competition law, the abuse of a dominant position, which personally I find here very likely. And there's also a special legislation which tries to deal not just ex post with this situation, but ex ante. That's the Digital Markets Act, which tries to make a gatekeeper control for larger companies like Apple. And under the DMA, there is an anti-steering rule, so it must be, you shouldn't sort of refer to, or you shouldn't make it difficult to sort of have cheaper payment options. And it should also be possible that third-party app stores are being installed on the device. And the EU fined 500 million euros for restricting steering in April last year. The investigation is still ongoing, but in some areas Apple has won, and now Apple Ads and Apple Maps are not designated under the DMA any longer, but with the App Store that's the case. Also in the US, suits are pending from the Office of Justice and also in the UK. So in summary, the pressure is on three levels. It's public antitrust enforcement under the treaty, the abuse of dominance. Secondly, the ex-ante regulation under the DMA, assuming the structural risk of gatekeeper power and prescribing how Apple must behave. And the last one is this private collective enforcement, which now the European Court of Justice has made easier.
Thank you, Professor Rösler, for your presentation. It actually got my attention because I've been dealing with competition law for a while. And we will have a Q&A, but I would like to ask you a question before that. This case was litigated before DMA, right? So, because DMA also prohibits, as you have mentioned, the anti-steering. And the case is still being litigated now?
It's still being litigated because the sort of damage has occurred. The Dutch consumers have paid too much.
And it's based on Article 102 of the treaty?
And on Dutch law on top.
On Dutch law as
yes.
well. All right.
And the Dutch court is going to hear the cases, and we'll see whether they grant the 650 million. But I think 30% is quite a bit, because we're speaking about a mass sort of channel through which these apps are being distributed.
Yeah.
30% is not in relation to the effort. If somebody really needed to distribute the app every time, and somebody human would be involved, but that's not the case, right? Basically all machines. Yeah.
Thank you very much. Thank you. So now I'll proceed with Professor Dr. Ece Başsözer. She's been a colleague at my university. We have worked together for a long time and still working with her. She was my first assistant indeed.
Yes.
And so it's a pleasure for me to be to chair her session. Let me introduce her to you. Ece Başsözer is a vice rector and full professor of civil law at Istanbul Bilgi University. She completed her PhD at Istanbul University, focusing on disgorgement of profits. Her research primarily concentrates on contract law, consumer law, and product liability, comparative private law, and international construction contracts. She has published extensively in leading national and international journals, including Journal of European Tort Law, European Review of Contract Law, and the Journal of European Consumer and Market Law. Professor Sözer has been a visiting fellow at the Max Planck Institute for Comparative and International Private Law on multiple occasions. She is also co-editor of the International Construction Contracts Conference series and actively involved in international academic collaborations and moot court coaching. And lastly, she's been also associate member of the International Academy of
Thank you very much. Let's celebrate that.
comparative law and yes.
Thank you.
And the floor is yours. You have 20 minutes.
Thank you, Hocam. Thank you very much for your kind words. And I have to say that I was very lucky teaching assistant, because I was working with him, especially. I mean, think of a professor that ignoring all of your faults and just focusing on the good parts. And yeah, that was great. Thank you very much, Hocam. Good afternoon, everyone. I mean, seeing that much people at this hour after the lunch break is really nice.
We have more people now, I think.
Yeah. I was
Something has happened
surprised,
here.
but I am very happy, of course. Good afternoon again. Thank you for being here, and I would like to thank to the organizers of this excellent conference, especially Başak Hocam and Pınar Hocam, but also to the silent and powerful team behind them, because I know how hard it is. It's really great. Thank you very much.
Yeah.
Let me start with a single question. You're a company that produces AI-powered medical diagnostic software. A patient is harmed because your system returned an incorrect result. The patient's lawyer reaches for the product liability rulebook. That rulebook was written in 1985, before the World Wide Web existed, before smartphones, and before AI was anything other than a concept. Does that a 40-year-old framework have anything sensible to say about your product? Of course not. As of December 2024, the answer is finally yes. With the new directive. Today I want to examine what the replacement means for the concept at the heart of the product liability, which is defectiveness. I will try to cover 6 themes. First being why reform was necessary. Second is how the concept of product has been expanded to include software and AI. Third, the core framework of defectiveness. Fourth, the 7 dimensions along which AI reshapes that framework, and the critical shift in the placing on the market moment and what it all means for practice. And lastly, I will close with a comparative note on Turkish law. First, why do we need a Reform, yes. The 1985 directive was built for a world of tangible goods. The bottles that explode, cars that fail because of manufacturing faults. And first, software was simply outside of the scope, and the Court of European Justice confirmed this in many cases, but especially in 2021 Krohn-Verlag case. Purely digital content is not a product. A company whose defective AI caused serious harm could argue, with of course a legal support, that the directive did not apply it at all. Second, the static moment of market release concept made no sense for AI. A system that learns continuously and receives over-the-air updates may behave quite differently in year 2 than it did when it left the factory. Pinning defect assessment to a single historical moment produces results that are both incoherent and unjust. Third, of course, it's very known concept, the black box problem. AI systems produce outputs through processes that are inexplicable even to their designers. Injured parties faced an almost impossible evidential task. Fourth, of course, since this is the consumer law, the main problem is the information asymmetry. Manufacturers know the architecture, the training data, and failure modes of their system. Injured parties, however, only know what they can observe from the outside of the product. The old directive offered no tools for addressing this imbalance. So it was so clear that we needed the product liability version 2.0. Yeah. The single most structurally important change in 2024 directive is what it does to the product definition. Under the old regime, as I mentioned already, software could only enter the liability framework indirectly if it was embedded in a defective hardware product and the hardware was defective. Standalone software had no direct route in. The new directive eliminates this entirely because Article 4.1 defines product to include software, and Recital 13 confirms this covers firmware and AI systems as well. A developer who releases a defective AI application is now unambiguously a manufacturer subject to strict liability. There is also a new category, related digital services, which are so essential to a product's functioning that the product cannot operate without them. So the cloud-based health systems, health analyst services linked to a wearable device is the paradigm case. Defects in that service can grant liability alongside the hardware. Of course, we have one important exception. Free and open source software developed outside a commercial activity is excluded, but once a commercial entity packages and sells this software for profit, the exemption falls away. Well, defectiveness is the linchpin, really. That means no defect, and that means no defect, no liability, regardless of how serious the harm. Article 7.1 states the rule: a product is defective when it fails to provide, first, the safety a person is entitled to expect, or that is required under law. So this contains actually two distinct tests. First being the legitimate expectation of safety test, which is a concept we already have known from the previous directive as well. This test asks what the public at large objectively expects, not the claimant, not this particular claimant, but the reasonable person familiar with the product and the product's nature and the context. In Germany, this is calibrated through the risk-utility formula. That means the manufacturer must take precautions proportionate to the magnitude of the risk, severity multiplied by probability, weighed against the cost of prevention. The cherry cake and airbag decisions from German Federal Court illustrate the range. No liability for cherry pit in a cake because the cost of inspecting every cherry is disproportionate. However, clear liability when an airbag deploys on a rough road because the stakes, life and physical integrity justify demanding the more. The safety required by the law test is newly introduced. It's not new for Turkish scholars, but it's new for, surprising, the European Union. Non-compliance with the mandatory standards triggers a presumption of defectiveness, but the converse is not true. Regulatory compliance does not exclude a finding of a defect. A baby stroller that passes every test still foreseeably traps a toddler's fingers may still be defective because the legitimate expectation of safety demands more than the minimum. Sorry. Sorry. Article 7.2 of the new directive lists the circumstances to be considered when assessing defectiveness. Several of these are directly responsive to the challenges regarding the AI. I want to highlight 7 dimensions of the change. First being machine learning post-market, connected products, and foreseeable intervention. The black box and its effects on safety expectations, cybersecurity matters, ongoing manufacturer controls, and the vulnerability of the intended user group, and of course the development risk defense. Article 7.2c requires course to take into account the effect of a product's ability to continue learning or acquiring new features after market release. This is a profound departure from 1985 directive. Consider an autonomous vehicle that 15 months after deployment causes an accident because of behavior that emerged from continuous learning. The relevant question is not what the system was like at launch, it is what the system was like when the accident really occurred and whether the risks it presented at that point met the legitimate safety expectation. This connects directly to Article 7.2e, which I turn to next. Under the old directive, defect assessment was fixed to a market release date. For physical goods, this is entirely current. For a continuously updated AI system, of course, it is not. The 2021-2024 directive's answer in Article 7.2e is straightforward. Where manufacturer retains the control after market release, the relevant assessment point shifts to the moment the control is relinquished. Recital 19 tells us what the control means in this context: the capacity to supply software updates directly or through a third party constitutes continuation of control. The practical result is that as long as the manufacturer is pursuing over-the-air updates, it continues to shape the product and it remains accountable for what the product does. The assessment window does not close at launch. It closes when the manufacturer stops actively shaping the product's behavior. Of course, one boundary worth noting, this applies to the digital updatable layer. Unchanged hardware components continue to be assessed against the standard at the time of the manufacture. It is controllable software and AI that attracts the dynamic analysis. The legitimate expectation standard must be reread when the product is an AI system as well. We have 4 specific challenges. First is the black box problem, which affects not just evidence, but the very formation of a safety expectation. If users cannot understand what an AI system does or how it fails, on what basis does a normative expectation form? Public expectations towards AI are still maturing, and the immaturity creates genuine legal uncertainty in applying the test. The second is emergent behavior. Outputs not derivable from training data places pressure on development risk defense, which I will come to shortly. The third challenge is user group vulnerability, which is addressed directly by Article 7.2h. The specific needs of the intended user group must be taken into account. For example, an AI medical device used in elderly care must meet substantially higher standards than an industrial AI used by trained engineers. And lastly, advertisement-induced expectations is also important. For instance, a manufacturer who markets an AI system as error-free or 99.9 accurate raises the objective standard, of course. The manufacturer's own claims become the benchmark for the defect assessment. Another dimension is the cybersecurity and the development risk defense. So we have two focused points here. On cybersecurity, Article 7.2f explicitly includes safety-relevant cybersecurity requirements within the defect assessment. An AI product that lacks adequate encryptation or for which manufacturer fails to supply a known security patch may be legally defective and not merely technically vulnerable. This provision operates alongside with the cybersecurity regulations, and non-compliance with those frameworks can ground the presumption of defectiveness under the Product Liability Directive. On the development risk defense, the classic rule allows a manufacturer to escape liability for defects that were genuinely undetectable at the time of the market release. But for AI, this creates a real tension. Emergent behavior and black box outputs can make undetectability claims plausible, but allowing manufacturers to routinely invoke this defense for AI failures would create a de facto liability-free zone for the most consequential technology of the era. The directive response is in Article 18, which empowers member states to remove the defense for specific product categories. Whether and how aggressively member states use this power, particularly for high-risk AI medical devices, will be one of the defining product liability debates of the coming area. And for that areas, maybe we may say that there's an enhanced strict liability, like hazard liability, as in nuclear power plants. Let's come to the comparative assessment. Before I turn to the conclusions, I want to step back and look at this reform through the comparative lens, specifically through Turkish law. Turkey makes a particularly instructive case. It's a non-EU country, but formally committed to aligning with the EU acquis, especially for the consumer protection law, but without the institutional pull of membership, so it's a bit confused, you know. It has transposed European Union product liability rules partially, blatantly, and with notable errors. And now it faces a situation where with the very directive we have transposed in 2021 has already been replaced by the European Union. The most fundamental problem is in Turkish law is structural. The Product Safety and Technical Regulation Code was designed to transpose both the 1985 directive and 2001 Product Safety Directive in a single instrument. That decision collapsed, a distinction that European Union law treats as foundational, the difference between product safety regulation and product liability law. These are, of course, not the same thing. Product safety regulation is ex ante and administrative. It prevents dangerous products from reaching the market. Product liability is ex post and compensatory. It addresses harm that occurs despite all the preventive measures having been taken. When you fuse them into one code and treat them as single, uniform form of responsibility, of course, both regimes suffer. The practical consequence is that Turkish law operates not with an independent concept of defectiveness, but with the concept of non-compliance, defined in Article 3, as a product's failure to meet technical regulations. The implication is stark. If there's a technical regulation and the product complies with it, liability is excluded. If there is no applicable technical regulation, which is very common, by the way, particularly for novel AI products, the framework becomes again uncertain. So, compare this with the European Union Product Liability Directive approach, which you can see on the right column of this slide. It's on your right? Yes, okay. The core concept is an independent defectiveness standard. The safety that public at large is entitled to expect. regulatory compliance is relevant. It is one of the circumstances listed in Article 7.2, but it's not determinative. A product that satisfies every technical standard can still be defective, and crucially, residual risks are covered. Liability extends to damage caused despite full technical compliance. However, under Turkish law, residual risks are not covered because of this structural problem. That is perhaps the most consequential gap. Strict product liability exists precisely to address the injuries that regulation cannot anticipate. The bottom line, which you can read in the footer of this slide as well, is this. Turkish law conflates product safety and product liability in a single code, a structural deficiency that has no parallel in European Union law. The 2024 directive, with its expanded product scope, covering software and AI, its dynamic defectiveness standard, and its explicit coverage of residual risks provides both the diagnosis of what is missing and the template for reform. Well, let me bring the presentation together in 5 points. I hope I have time.
Yep.
One is, the first conclusion is standalone software and AI systems are now definitely products. According to the directive, a 40-year-old debate is closed. Software developers are manufacturers who subject to strict liability. 2, defectiveness has been dynamized. Liability follows manufacturer control across the product life cycle, not a fixed point of a single market release. 3, the legitimate expectation standard is now multi-layered for AI. It encompasses technical compliance, explainability, cybersecurity, emerging risk management, and user group sensitivity. 4, the burden of proof has been rebalanced, where technical complexity makes proof excessively difficult, presumptions of defect and causations are available. The black box, which once protected the manufacturers, now may trigger liability. And lastly, Turkish law has significant ground to cover. The current framework builds around non-compliance with technical regulations rather than an independent defectiveness standard, does not protect against the residual risks, and has no adequate answer for AI-specific challenges. Thank you very much.
Well. Thank you, Professor Suzal, for your nice presentation. I understand that Turkish law has defects concerning product liability, but
Yes.
does the law currently applies to AI products or not?
No.
It does not cover it.
Yeah, it does not cover it, no.
Okay, all right.
We may force to read it that way, but it's almost impossible.
Okay. Okay. All right, now the final speaker, Associate Professor Pınar Çağlayan Aksoy. Let me introduce her before her presentation. She's been working as a faculty member in the Civil Law Department at Bilkent University Faculty of Law since 2017. After receiving her undergraduate degree from Bilkent University Faculty of Law, she completed her graduate and doctoral studies at Ankara University Faculty of Law. She is a member of Blockchain Turkey Platform, Istanbul Blockchain Women's Association, and Zurich University Blockchain Center. As a member of the European Law Institute, she actively takes part in projects. Pınar Çağlayan Aksoy's books, editorials, and published articles in the fields of international sales law, comparative contract law, consumer law, and tort law. Her research in recent years has focused on contract law, tort law, and personal data protection, as well as the legal effects of emerging technologies, especially artificial intelligence and distributed ledger technology. I know you because of your book, the economic laws. The Turkish version was different, but yeah, that was my
intersection.
yeah, we had the intersection. Floor is yours.
Thank you very much. May I use the
However you like.
chair?
This is your university, right? Your conference. You can use whatever you like.
Thank you. Can I have the pointer too?
Yes.
Thank you. Okay. Good afternoon, everyone. I salute you all and thank you very much for being here on a Friday where the weather is extremely nice, and it's very difficult to be the final speaker of the day. And I promise to keep it engaging and bore you as less as possible. So I'm going to be talking about dark patterns, choice architecture, and the limits of consumer autonomy in EU digital law. And I have to say something frankly. The thing is, when I initially, I had been working on dark patterns for some time, but when I wanted to approach the issue from an EU law perspective and have a comparative view, I realized that my job was really, really difficult. So I'm not sure if I will be able to fulfill that. I did it in PDF, that's why I'm having technical difficulties probably. It's in PDF, İlayda Hocam. I think that's the reason why. Oh.
Try it again. Maybe it's too far.
I'm not sure. I'm not sure. It was working in the morning though. Okay, thank you. So I'd like to start with the everyday manipulation that all of us actually face during making our research. We also talk about this when we are dealing with social media, and this has become an internal part of our lives. So the central question that I want to address during the speech is, does EU law really protect consumers' ability to make autonomous decisions in digital environments? And of course, to answer this question, it's really important how we understand autonomy. And my argument in this presentation will be that dark patterns expose a structural weakness in classic consumer law, and the traditional consumer law model assumes that if information is disclosed in a transparent way, autonomy is preserved. But in digital environments, as we have been talking since the morning, interface design itself has become the mode of influence itself. So the key question has become, is not any longer whether the consumer was informed, but whether the architecture of the choice preserves the conditions of autonomous decision-making. So this is the whole problem that we are going to begin with. So can we go back, İlayda Hocam? So the real problem arises actually from a very simple, thank you very much, very simple observation. The real problem with dark patterns, and I'm going to tell you about what I understand from a dark pattern in a minute, is not only that they are misleading. It is that they reorganize the conditions under which consumers make a choice. So in that sense, as the slide also wants to highlight, these are not isolated practices, but they are elements of continuous interaction over time. And now I would like to move on to some examples of dark patterns, which will show us that they are not really isolated practices, but they are elements that show continuous interaction over time. The first one is the cookie banner asymmetry that we are probably all used to. We all recognize this example. Cookie banners are the ones where you can accept immediately, but if you want to reject these cookies, then it requires multiple steps, times, and possibly the mistakes that you might make. If we can move on to the next slide, sometimes we see the fake urgency dark patterns, whereas we can see on the slide, hurry up, the sale is ending in a fictive minute, so only one item left, or any disclaimer which creates an artificial urgency would be regarded as a dark pattern. And moreover, we can also talk about the Roach Motel or hard cancellation type of dark patterns, where the model is designed to be easy to enter into, but really difficult to exit. And in that sense, I would like to basically really quickly quote the example given by, although I will be talking about the EU in a minute, I really basically want to talk about how the United States has addressed this. The Commission of the FTC in the United States has stated the following: too often, businesses make people jump through endless hoops just to cancel a subscription. The FTC's new ruling, given a few years ago, will end these tricks and traps, saving Americans time and money. Nobody should be stuck paying for a service they no longer want. And interestingly, this decision was given in a case where actually the entering in process was standing out as an experience. So they had a patented just one-click checkout, and in 2007, it was described as a game changer and a turning point for Amazon. However, due to this dark pattern design in the following years, Amazon clearly demonstrated a mastery in reducing friction at the time when they wanted you to complete an action. But when it came to unsubscribing from Prime, Amazon clearly added steps and complexity to the issue, which was again regarded as a dark pattern. So these are basically what we call dark patterns. There might be some different interfaces that we come across with. However, they all have the same underlying logic, is that they are trying to steer behavior through design. So if we can move on to the next slide, thank you, İlayda Hocam. I wanted to show these examples to convince you that this is not only just deception. These examples reveal a structural asymmetry of power over the decision-making environment. And businesses increasingly control how and what consumers see and how they make their decisions. And crucially, we are continuously observing that these effects are not limited to one single moment, but they are often coming off as cumulative and they unfold over time. So if we can look at the empirical evidence, the EU Commission's sweeping in 2022 reveals some very important results. And it was found that there were widespread use of dark patterns across EU websites, and it was also shown that dark patterns are not just marginal abuses, but they were systematic features of the digital markets themselves. So it wasn't only incidental, and it was seen as a systematic failure of the digital markets. So if we can move to the dark patterns. So we have formulated the examples, we have shown the emergence of the issue and why it is important right now to address the issue. We all have to take into account the common elements of what makes a dark pattern a dark one. So the dark patterns are commonly mostly understood as interface designs that manipulate or distort decision-making. We will see many different definitions that try and define and understand dark patterns, and we don't have one single definition, but we know that they operate through deception, through manipulation, and through friction. And the key point is that they do not just affect information, but they affect the decision-making process itself. So they must be best understood as a part of the digital choice architecture that we have made. And as this slide shows, the issue regarding dark patterns have evolved significantly. At first, the issue began as a user experience problem. Then it became in the phase 2 a behavioral issue, which was exploiting cognitive bias. Today, it's clearly a legal issue, and it's about more than one legal field. It includes competition law, data protection law, consumer law, as well as tort law. And I think that there is also a fourth dimension that we should be taking into account, and it's about infrastructural power, scale, and continuous interaction over time. So digital platforms can test and optimize interfaces across millions of users, and this transforms manipulation into a systemic and ongoing process. So if we look at the normative frameworks that we have to deal with, we can say that there are different approaches that have emerged to conceptualize this problem. Some of these approaches focus on the autonomy side, and they try and figure out whether decision-making process is really impaired. The others focus on the harm, if there is financial, privacy, or emotional harm, which is really hard to detect and prove, as we have seen in the presentations in the morning. A third approach focuses on the loyalty part, which I will elaborate on further, whether firms exploit their position to the detriment of users. So these logics that we see on the previous slide, sorry İlayda Hocam, they operate simultaneously, but they don't have a unified framework. So this leads me to my core, the main argument. Autonomy alone is insufficient. The law needs a relational normative anchor, which loyalty may provide. So loyalty could address asymmetries of the environments. But how? So autonomy explains what is affected in a nice way, but not always why these practices are wrong. So I will propose complementing the autonomy with the idea of loyalty in design. So dark patterns can be understood as disloyal design practices where firms exploit asymmetries of power in digital environments. So this will kind of shift the focus on the dark patterns from individual decision-making to relationships of power and trust. And when we look at the EU legal framework after my proposition, we will see that the European Union has responded to dark patterns through multiple legal instruments, and we have been talking about most of them since the morning. So we have the UCPD, which addresses misleading and aggressive practices, the GDPR that regulates consent issues and introduces data protection by design, the DSA, which explicitly prohibits manipulative interface design under Article 25, the new AI Act, which targets high-risk manipulation, but in a less concrete way. We have the Digital Fairness Act, which is currently under development. So we see that there is a fragmentation in EU law. But the key point is that each and every instrument that we have listed here addresses dark patterns through a different logic: unfairness, consent, autonomy, and harm. So if we can move to the next slide, we believe that the next one, please. The DSA is particularly important in that sense because its Article 25 prohibits designs that deceive, manipulate, or distort decision-making. So I think that this is a major innovation, but it still remains limited to interface-level interventions like we talked about in the morning, and it does not fully address broader behavioral processes. So as a result, we see that the fragmented framework still remains. There is no single instrument that we can take into account that fully captures the full reality of digital choice architecture, and importantly, it fails to capture continuous behavioral processes. So if we can move on, this brings me back to consumer autonomy. As we have seen with some of the examples, the EU law increasingly focuses on protecting decision-making autonomy. But autonomy is at the same time also mediated or even delegated to digital systems, as we have seen in the AI agents, as Teresa has mentioned. So this raises a deeper question. What does autonomy mean in environments that are shaped by algorithms and designs? So we see that this leads to certain limits. First, fragmentation, the limits caused by fragmentation. So the consumer receives different levels of protection depending on whether the issue is framed as unfair commercial practice, with an issue about the consent architecture, platform design, AI manipulation, or data sharing interface. Second, there is definitely an over-reliance on disclosure. So many dark patterns work precisely by neutralizing or bypassing disclosed information. So disclosing of information is not enough. And third, there is a mismatch between the law and reality, as it was mentioned in Monica and Kasper's speech just before the lunch break. So we can see that although law and legal systems focus on moments, in reality, digital influence operates continuously. So this brings me to another point where we also have talked about vulnerability for several times. In addition to the limitations that I have talked about in the previous slide, at the same time, digital environments transform the concept of vulnerability itself. All consumers are potentially vulnerable due to data asymmetry, behavioral targeting, and real-time optimization. So we can say that digital vulnerability is not only structural, and it's not really exceptional. So before wrapping up my ideas, I would also talk about the enforcement problem. The law is becoming more and more ambitious at the level of prohibitions, but we see that it still remains weak in the concept of proof and remedies. So there is a key issue in detecting all of the limits that I have been talking about. So there are still many difficulties in identifying and measuring dark patterns in limit enforcement. So this is something that we should be talking about. And when we are looking at the future, I think that there are several directions that are emerging. So I believe that parallel to the GDPR, we need fairness by design. We need stronger evidentiary tools and recognition of cumulative and collective harms in a specific and unified way. And maybe most crucially, we must regulate not only individual interfaces, but the interaction trajectories over time. To conclude, dark patterns reveal a fundamental transformation in the consumer markets, and the problem is no longer only misleading information on the consumer side, but it's the design of the decision environment itself. If consumer law is to remain effective and it does not suffer from a silent death, it must regulate not only what the firms and businesses say, but how they structure the choices the consumers face. And this ultimately requires a shift from transaction-based to process-based consumer law. And on that note, I thank you very much for your attention.
Thank you for all the speakers for their valuable speeches. Now I would like to invite Associate Professor Pınar Çağlayan Aksoy to conclude our conference. Thank you.
Thank you very much. Thank you all for being here. You have seen me too much, so I'll try and keep it short, but I think that there are some things that we need to note down in the history because many important establishments were made during the speeches of the fellow speakers. And what was striking for me was that although the 9 speakers today all approached topics from a different angle, be it dark patterns, AI contracting, vulnerability, platform governance, evidence, or liability, we have all been describing the different dimensions of the same transformation of consumer law. So we talked about what has changed in all the presentations. It was a common starting point. And we all agree, I think, that the traditional consumer law was built for a world of discrete, observable transactions, a world in which there is a moment of persuasion, a moment of decision-making, and the moment of the conclusion of the contract. But as Professor Namysłowska showed us in a convincing way, this is no longer the reality of the digital world. So in digital environments, there is no clear moment of decision-making because the system, especially systems that are backed up by AI, there is no clear moment of decision-making. The system interacts continuously with the consumer, shaping their behavior over time and often in an irrecognizable, invisible way. So when we look at different dimensions, we can start maybe with the first transformation, which is the shift from transactions to processes. So again, in the morning, we showed that EU consumer law is mainly organized around identifiable moments, but digital markets operate as continuous interactions. And Dr. Drazewski complemented this argument by demonstrating that in these kind of environments, the evidence is simply disappearing. And as he put it, you cannot screenshot a process, and you cannot reconstruct an interaction that folds over a time. And this connects directly to the problem of dark patterns that I tried to discuss a minute ago. These are not isolated design choices, but they are elements of continuous behavioral influence over time. So I think that in the end, we are left with a fundamental mismatch. The law looks for moments, but the market operates through processes. The second stage is the shift from autonomy to structured and delegated decision-making. It concerns actually the concept of autonomy, and what we understand traditionally from autonomy is making informed decisions. But since our first speaker of the day, Professor Teresa, demonstrated, decisions are increasingly being mediated or even taken by digital assistants and AI agents. And this raises very fundamental questions, such as who decides, who makes the decision, who is responsible, and in this kind of perspective, can we still meaningfully talk about a consumer choice? At the same time, as we have seen in the discussion on dark patterns, even when humans formally make a decision, the environment in which they decide is actually already structured. So the autonomy idea is not only constrained, but it's increasingly designed and delegated. This brings me to the third shift that I want to talk about, and it's the shift from individual weakness to structural vulnerability. And this transformation, this shift is about the concept of vulnerability. In this case, Dr. Aksoy showed us clearly that vulnerability is no longer an exceptional concept, but it's rather structural and universal in digital environments. This is due to data asymmetry between the subjects, behavioral profiling carried out, and real-time optimization. And this insight actually strongly reinforces the analysis of dark patterns again, because these kind of practices do not simply exploit pre-existing weaknesses, but they actively produce and even amplify the vulnerability issue through design. And the fourth transformation is the shift from contract to platform power. As Professor de Elizalde has argued, platforms are no longer merely contractual counterparties. They exercise a form of private regulatory power. They shape the behavior, they shape the markets, and they even have the power to shape normative frameworks. And this, I think, would shift our perspective entirely, because as lawyers, we're no longer dealing only with contracts between parties, but with systems of governance embedded into digital infrastructures. And this brings me to the fifth shift, from liability to dynamic risk and control. Finally, I think we saw how these transformations affect the issue of liability. The presentation on AI products liability delivered by Professor Süzel highlighted how the concept of defect itself is changing. It's no longer static, it's tied to the moment a product is placed on the market. Instead, it becomes dynamic, it evolves over the life cycle of AI systems, and this reflects a broader shift from ex-post responsibility to ongoing ex-ante controls and risk management. So to put all these contributions together, I think that we can have a rather clear picture. Consumer law is undergoing a clear transformation along three main areas. One of them is the temporal axis, from moments to processes. The second one is the structural axis, from individuals to systems of power. And the third one is the normative axis, the shift from information to design and control. And across all presentations, I think we can grasp one idea, that the object of regulation is no longer the transaction itself, but it's the environment, the surrounding in which the decisions are made. So where do we go from here? If the problem is continuous, structural, and data-driven, then our response as lawyers, as lawmakers, as policy originators must also be continuous, structural, and proactive. This is why many contributions that we heard about today implicitly or explicitly pointed toward fairness by design, stronger evidentiary frameworks, and more systemic forms of regulation. So, as a final remark, I believe that we must move from asking, was this practice unfair, to asking, does this system, over time, undermine autonomy? Thank you very much for being here today. Thank you to all the colleagues, all the guests. Thank you very much. Thank you.